Good afternoon. I'm Michael Strom of Oasis Senior Advisors, and today we are interviewing Shauna Anderson of Anderson Law. Good afternoon, Shauna.
Good afternoon, Michael. Pleasure to see you today.
Nice to see you. How are you today?
I'm doing very well.
Wonderful. I was wondering, could you tell us a little bit about your law practice and yourself?
Of course, I'd be happy to. Hi, I'm Shauna Anderson, and I am an estate planning attorney that practices primarily in North Orange County, but I do practice all over Orange County. I'm a certified specialist in estate planning, and so I've dedicated my career to only practicing estate planning. And I enjoy getting to know my clients and their families and really assisting them in this important aspect of their life. And one of the keys to my practice is that I'm a native to Orange County. I grew up here and I went to a local high school not too far away, and I have 3 children of my own, and so I know the importance of planning because I'm actually able to assist in my own plan for my family.
Well, thank you, Shauna. So could you tell us a little bit about what happens if you change your mind after you've already made an estate plan?
Yes, of course, I'd be happy to. So when a client happens to change their mind, whether it's a month or a year or 2 years or 10 years following the execution of their original plan, this is going to be one of the most important times to contact your estate planning attorney to just review the consequences of what it is that you've changed your mind of and how it will impact your plan. So contacting the attorney is definitely going to be the highest recommendation that I have for you. And then that way they can go through and assess your risk that you may have and get you a few maybe recommendations as to what they would propose would be a solution to that.
Well, thank you, Shauna. So let me ask you another question. If the size of my wealth changes since the original estate plan was drafted, how do we work with that?
Well, that's something that we should definitely talk about.
Great.
So the size of your wealth is definitely something that is taken into consideration when planning. So one of the recommendations that I would also have is if your wealth happens to increase or your wealth happens to decrease, you definitely want to talk to a professional about that and see what the implications are. Because sometimes an increase in wealth is going to cause a different tax strategy that the estate planning attorney may want to do. So definitely pick up the phone and give your estate planning attorney a call, because at the time that it either increases or decreases, you don't want to have too complex of a plan, or you don't want to have something that is too simple at the same time. So definitely pick up the phone.
So Shauna, what happens if my marital status changes? How does that affect my estate plan?
Sure, I'd be happy to help you with that. So your marital status is definitely something that you want to discuss with your estate planning attorney, because depending upon your marital status and whether it's changed or not, there may be different edits that need to occur to your estate plan. For instance, if you recently have lost a spouse, it may be important to address the estate plan because now you may have powers of attorney and that state specifically that your spouse is going to be your first agent. And sometimes that may cause a little bit of a hiccup in the road. So sometimes it's important to address your estate plan at the time that your marital status changes. Or just informing your estate planning attorney of your marital status is certainly important, because if you happen to be married but you're creating a plan all on your own, we definitely want to take advantage of being able to plan for you, but yet we still want to make sure that we're complying with the requirements and addressing the fact that you are married and needing to make sure that we're taking the steps to protect you so that you don't run any hiccups down the road if you happen to predecease your spouse.
So Shauna, if one of my beneficiaries becomes disabled, is it important to let my estate attorney know about this?
That's a great question. Making sure to give your estate attorney a call at the time that you find out that one of your beneficiaries may become disabled is definitely something that needs to be communicated. At the time that someone becomes disabled, they may go on to a government benefit that allows them to have tremendous health benefits from an insurance standpoint, and it may give them benefits that they would not otherwise receive if you pass away and leave them a large sum of money. So making sure that we take proper steps to protect them and secure the government benefits is something that we may want to do. And so by being able to protect them, you can set up a special needs trust. And so making sure that we take those steps is something that you want to discuss with your estate planning attorney, at least to know what your options are to protect that beneficiary.
So Shauna, what should I do if my spouse starts to become forgetful?
Sure. So dealing with a spouse who may start to get forgetful is not only emotionally trying for most of the people that I deal with, but it also becomes challenging and sometimes frustrating. So one of the things that I certainly do recommend is that you give your estate planning attorney a call and you talk about it, because there are certain documents that we want to make sure that are in your estate plan. And so having a chance to review that estate plan before it may be too late to be able to make adjustments is my strongest recommendation. So making sure that clients know that you don't want to be hasteful in this situation. You want to get in, you want to review your plan, you want to know what risks you may have and what the recommendations are that the estate planning attorney recommends to make sure that you have all the necessary protections available that the law will allow you.
So Shauna, how do I handle retirement accounts as it relates to my estate plan?
Sure, that's a great question, and a lot of people get confused on that. So retirement accounts are definitely going to be one of the trickier parts of the estate plan and trying to make sure that they're handled correctly. Because if you have a retirement account, you have to decide how the beneficiary form should be addressed. Retirement accounts are something that should never change ownership out of the individual that owns them. You certainly want to make sure that you're handling them correctly at the time that you do pass away, that the beneficiary form is going to direct the money in the manner that you want. But there's so many rules and regulations that you need to know your options, and you need to have somebody assist you in making sure that you're addressing your retirement accounts correctly. There are certainly some advanced planning options, such as maybe a retirement trust would be appropriate for you, but making sure to get educated on what your options are and what is definitely the best for you and your family is my strongest recommendation. So do give your estate planning attorney a call and see, maybe a retirement trust is something that would suit you and your family the best, but making sure that you address those beneficiary forms is what you need to do. I have had a client once whose husband passed away, and unfortunately, she was not the named beneficiary. There was nobody named as the beneficiary on his retirement account. And it did cause that account to have to go through probate, even though she was alive. So failure to properly address these accounts can give significant consequences. And when dealing with emotional stresses that are related to losing a loved one, just escalates just the inconvenience factor as well as the headaches that are involved when having to collect that kind of money. So just give someone a call and make sure your affairs are in order.
So Shauna, is there any recent privacy laws that have really affected estate planning in the last 10 years?
Yes, there are. That's a great question. So there are some recent laws that you certainly want to address and make sure that your estate plan does provide for what's called a HIPAA waiver. It's Health Insurance Portability and Accountability Act. And what it does is it makes sure that if you need someone to step in to make a medical decision with you, or for you rather, they're going to have all of the necessary medical information to make an informed decision. So it works in conjunction with your power of attorney for healthcare to make sure that the same people that you've named in your advanced health care directive is going to have all of the pertinent information from the doctor to make that best choice for you. So if you have not had your plan reviewed in the last 10 years, this is definitely something that you want to make sure that you discuss with your estate planning attorney and take proper steps to make sure you're protected in case of someone needing to make a medical choice for you.
Well, Shauna, thank you so much for giving us all that information about estate planning. So if a client would like to reach you for questions or other resources, how would they get in touch with you?
So I'm always happy to answer questions and educate people about the importance of planning. So the best way to reach me is going to be, you can call my office at 657-387-1108, or you can certainly take a look at my website, which is octrustandwills.com.
Great. Thank you, Shauna.
Thank you.